Our next speaker, I'm very glad and honored to present Mr. Zvulun Tomer, whom I'm happy to say is not a lawyer. However, Mr. Tomer is as proficient an advocate as any lawyer in this area. Mr. Tomer is the founder and the manager of Unifarm, which is a manufacturer of generic pharmaceuticals in Israel, and he is involved in development projects in the pharmaceuticals and the chemistry area. He is a professional gentleman. He is active in the Manufacturers Association of Israel and chairs its professional committee. He is also a member of the public committee nominated by the Minister of Justice for reviewing the Israeli patent law. So Tomer, chair is yours. Thank you.
So the first thing I would like is, for the fairness, I would like to declare that I am a generic manufacturer. I'm owning the company, I'm managing it. Only to clear the situation to the audience, Israel is one of the most modern and demanding patent law in the world. The problem is that the implementation brings a lot of harm to the generic industry. So pharma is not to complain about intellectual property problems in Israel, maybe about data exclusivities, which I will discuss just now. There are some problems, maybe, I'm not sure about, as you will see. And first of all, I would like also to say, that there is no doubt that the innovative companies which are bringing first to the market a new chemical entity for medical use have to be fairly compensated for their research expenses, efforts, and inventiveness. No doubt about it. On the other hand, these companies must understand that it is their obligation to adopt fair competition practices and not to abuse the patent system. As you will see later, if I will have enough time, we'll show you what I mean by abusing patent system. There must be a balance between the innovative companies' desire to what they are calling unfair competition and the interest of the public to avoid unfair monopoly. After the TRIPS agreement, monopoly for pharmaceutical products may be obtained by two parallel and independent systems. One is the patent system, and the second is data exclusivity, or how it is called in the States, marketing exclusivity. TRIPS is dealing with intellectual properties issues. Data exclusivities, as outlined in Article 39, aims to protect intellectual property rights. There is no place, to my opinion, to protect the same rights by two systems. Under favor behavior, one system is enough. The data exclusivity system is a new system compared to the patent system and is dealing only with pharmaceuticals and agricultural products. It seems that the negotiators, when concluding the TRIPS agreement, wanted to give a more efficient monopoly for pharmaceutical and agricultural products, and the criteria for obtaining such monopoly requires only that the new chemical entity will be the first to be launched as pharmaceutical or agricultural product. While introducing a data exclusivity system, it was the duty of the negotiators to check the actual standing of the patent system, to examine the development of the patent practice as a result of court rulings, and to check whether the practice conforms to what the patent system meant to be according to the patent conventions, and to check whether actual practice does not contribute to abuse of the system contrary to the public interest. The negotiators did not ignore patent issues, which are discussed in Part 2, Section 5 of the TRIPS Agreement. Most amendments made by the TRIPS in this section reflect strengthening the patent system in favor of innovating companies. It seems that the negotiators ignored the abuse of the patent system by innovative companies, thus causing very heavy damages to the public interest, and this is because most probably the leading influencing negotiators represented developed countries which are housing the innovating companies. The abuse of the patent system was made possible because of some additive factors, as I will mention. One, court decisions which did not take in consideration public interest and which became practice of office. Here I must emphasize, when we are speaking about public, the companies are also a part of the public, but I refer to the public of users and not to companies. Now, because I don't want to revert and to open a discussion what was behind the patent system, giving monopoly against what, etc. Then the second factor is inability of patent offices to cope with the sophistication of the innovating companies and their experts. The third factor is there is no clear demand that an inventive step has to show advantage, even a small advantage, but of real value over the prior knowledge or prior art. That the fourth one is that the invention has to contribute something of value to the public, even minimal. Today, there is not such demand, which was one of the first reasons in the balancing of the patent system. No contribution to the public, even a minimal, is not requested. And the fifth, from a formal aspect, the first sin in the patent system is that the patent application is not to be accompanied by a declaration that it contains is true. And this is very strange. For things less than a monopoly, you are requested, or someone who is applying for is requested to give declaration that he has the force to fulfill the requirements. Here, nothing. You are taking a sheet of paper, you are writing what you are writing, and that's it. Then go to courts, then everything is open. No undertaken, nothing. This is the first sin, to my opinion, because such legal and important document without a declaration, it seems to me very strange. I know that they are now speaking about a convention that even what is requested now is saying too much. It may be even in handwriting to write something, I have invented so and so, and it will be good for 15 or 18 months until you will give all the other data. Further negotiations of TRIP must refer to the above points. Otherwise, the patent system will continue to be abused contrary to the public interest. If at the 60s, appellants knew that the patent has to show some real and valuable advantage, in our days it's enough that the so-called invention is new. On this, everyone knows that it cannot be given up, it must be new. And as to the inventive step, it's enough to smear superlatives about properties without mentioning any advantage and without showing in minimal inventive sparkle. Before marketing a new chemical entity or close after the marketing, the innovative companies are applying for additional patents which do not present any advantage over the prior art. They contribute nothing of value to the public. Those patents are not intended to be used by the innovative companies. The only aim of those applications or patents is to prolong monopoly on new chemical entity. The number of patents listed in the US Orange Book for each medical chemical entity witnessed the policies to prolong monopoly. And I must say, yesterday we heard from Yehuda Libne that 75% of litigations in the US are terminated by declaring that the patent is void. If this doesn't show abuse, I don't know what shows abuse. So, in this case, I would say that before entering even to discussion about data exclusivity, one has to clear the table. And this is the task of TRIPS. This might be the task also of WIPO. I don't know who, but it cannot continue, as I will show you later, if I will have time, in some cases. The unlimited resources of the innovative companies are ready to invest for prolonging monopoly by legal procedure. It is not balanced with the resources of the generic companies that generic companies can spare for these purposes. For immediate action to stop the abuse practice, the TRIPS negotiator must find a way to define precisely criteria for the term inventive step and bring it in the lines with what the inventive step meant to be before those who founded the patent convention, thus avoiding abuse of patent system. Until those measures are taken by TRIPS, as long as abuse of patent system aim to prolong monopoly will not be stopped, it will be only fair to cancel, I repeat, to cancel the exclusivity data system or to narrow it to the interpretation, to the exact interpretation of Article 39 to the minimal demands about the decision of the Israeli court. Mr. Band already cited the decision of the Judge Engelhardt, and what I would like to say, as long as the abuse of the patent exists, I do not see any reason why Israel has to amend any of its law, and I would say categorically that it has not changed any of the law procedure for registering generics. To avoid misunderstanding, I would like to emphasize that Israeli health authorities do not disclose confidential data to third parties. And now I would like only to give you a feeling what I mean by abuse. And abuse generally and abuse in Israel. Abuse generally, I mean if we are taking and coming back to the development who knows chemistry about Markush, saying claim. The Markush claim Now you see here a patent. I have just taken it from the last patent journal, Gazette. You see here a very simple molecule, but you see how many alternatives can be, or what we are calling substituents. Believe me, here we have tens of millions of molecules which are protected by a patent which only showed 100 examples, if I will take. So how is it possible to get protection on so many molecules? Then why I am saying it? Because 5 years later, 6 years later, the company is coming, now they are saying, you know, this was too large, that's right. Now I am taking a patent only on 100 molecules. And the time starts to run for monopoly from the new date. 5 years later, they are coming. Now we have a source for it. Now it starts to run again. This is an abuse. And what's strange is in this case that the way to manufacture all those molecules are not enabling what is called today and which is needed today. When I am coming to oppose a patent, I am bringing a citation which declares prior art, but declares the molecule even. Then I have been told, no, these documents are this. So how is it possible, if this is not an abuse, to grant patent on such large team of molecules without even explaining how to prepare them? And when I am opposing to a patent, they are saying, yes, but it's not written enabling. It's not enabling according to this. What I would like to say, and to resume, I have a lot of other examples to show you if I will have time later, that this cannot continue anymore. If Professor Edelman said before that we have to pay for our drugs, our generation have to pay for our drugs, but it will be free for the next generation, maybe it's a good idea, but it's not reality. The reality, Professor Edelman, that our generation will pay and the next generation will pay because the multinational companies are adopting a practice that is abusing totally the patent system. And only to resume, to my opinion, unless this will not be settled, we have not to speak at all about data exclusivity. The monopoly given by the patent system is enough and over than enough. Thank you.
Promised you a treat. Thank you very much. I'd like to now take a few comments from the audience, if there are any such, and I would ask you kindly to limit yourself to relatively short ones, because I do want to return to the panel and hear very, very brief additional responses, if there are any. Anyone? Eran, please.
Thank you. As a comment, I will be brief, although we've been discussing these issues for a long time, and certainly during the last 2 days, we're much further. Last night I thought perhaps I should write down my notes, but as usual, I have to be more brief. My first comment is, I think that it is unfortunate that to date, the public debate focused on the question whether there should be or shouldn't be data exclusivity in Israel. And it was the position, I would say, the relentless position of the generic pharmaceutical companies and the generic companies that there shouldn't be any protection in Israel. And it is unfortunate, first of all, because it came like that, the legislation almost passed without public debate as to the contents of this legislation. And secondly, because at the end of the day, as we all now appreciate, there will be such legislation, it's much more important to speak about the contents of the legislation. Even today, when Mr. Ban spoke, he said about the secret that was revealed yesterday. What are the contents of the proposal that is going to go through with the government? It should be open to the public so that everyone should have an opportunity to respond. And I will not say much about Article 33.9. I will just say that it is sufficient to avoid the disclosure. This, I think, to everyone seems a weak argument. There has to be something in addition. Admittedly, Article 39.3 may be somewhat vague. Maybe one could accommodate the requirements not only by data exclusivity, but by other means. But something has to be done. And we must admit that the position here in Israel that we do not have any protection whatsoever, no data exclusivity, and not any other protection. And if the patent system does not solve this problem, and we know it because we are speaking about a lot of information, efforts that has to be generated in the many years to follow after the synthesis of the molecule. And The point is, that, as Mr. Ban said, that the government took the position that nothing needs to be done because there are other laws under the civil law legislation. If this is the case, then the Israeli government and the generic manufacturers are in breach of those provisions for many years, which goes to show that there has to be some legislation with some public debate with respect to the contents of this legislation. Another short comment. I would think that in a state like ours in Israel, it would make sense to encourage such sort of new semi-IP right. We want to encourage innovation. We want to encourage gathering of information regarding clinical data, meaningful clinical information. We are a small country with somewhat small ethnic groups. We want to encourage pharmaceutical companies to conduct research in those areas. It would have made sense to enact such legislative scheme like the orphan drug, and it's a pity that we did not do it until today. Thank you.
Thank you very much. Very, very brief comment. Yes, Amir, please keep it short if you will.
Thank you for that talk. I'd like to offer one additional conceptual support for the position of Mr. Tomer. I believe that the patent system as such is intended to advance society through providing an incentive for the inventors to innovate. But the patent system does not talk about maximizing profits. Hence, there is a leeway between giving the incentive and providing, as you say, the abuse of the system by the patent holders. So I think that the balance should be somewhere in between, giving the innovator's right of monopoly to a certain extent, whereby you also consider other considerations such as the benefit of society, or in your case, the generic producers of medicines.
Thank you. Yes, please do.
This is the question to Mr. Tomer. If you believe that the patent system is so complete and it would answer all the questions, all the problems, what about the situation where, and you know,
Then just 5.5 hours is just too long. So please, if you would be so kind as to restrict yourself to 90 seconds of response, and we can continue this wonderful multilogue afterwards in less formal settings. Mr. Bant.
Sure, Susan.
We're counting.
60 seconds of your time because I'm sliding 39.3. Very brief. First point, I apologize to Susan if she was offended when I used the term medicines boycott, and I will not keep that term for now. But putting personal issues aside, I question the statement whether indeed Parliament members do not register medicines in Israel because they do not enjoy protection, or IP protection. And I suggest that you check that again with your members, and would supply you on the way with 2 examples. One being a product of Amgen, Ulasta, if I pronounced that correctly, which was launched in the US over 2 years ago, never introduced in Israel. It's not a small product. It treats side effects, sometimes fatal side effects of chemotherapy, and is considered like a situation, obviously. It sells in the US over $1 billion. It's not here. And the patent in Israel expires, to my knowledge, in February 2015. So that provides enough protection. Another example, exemplar kidney failure, introduced in the US, May 1st, 1998, sells in the US over $300 million a year, still not in Israel. Patent protection for that did not expire before 2010. That's my first comment. Second comment is my personal vote. Yes, I was a member of the experts with recommendations to the government on TRIPS implementation, and I'm not going back to my recommendation. I'm flattered when you say that this was the voice of Israel. This was the position of Israel. It was our position. And I think that if you as pharma are willing to close a deal on those recommendations, new chemical entity, 5 years, I think this symposium is going to mean a lot, to save a lot of time for the Israeli government. And I'm curious to hear the reply on that. And third point, Jordan. My understanding is that the free trade agreement with Jordan, which you mentioned but did not go into, require Jordan to provide a term of protection, which depends upon the length of protection in the country where the information was made. So if it was made in Europe, it would need to provide that longer protection, and that the free trade agreement also referred to new indications, but the Jordanian law ended up with 5 years, as you said, 5 years on new chemical entities.
Thank you, Ben.
Okay.
Thank you, Tal. Perhaps
Thank
we
you.
can. Thank you very much. Please.
Take the last first. Jordan, as I said, is having continuing reforms. They changed their laws and it came in on May 2nd, 2000. That met their TRIPS obligations. There's currently a committee on law and regulation to provide the additional 3 years. And I actually just met with the Director General of the new FDA in Washington. They have every intention
So they're working on it.
they're working on it. But it's a small country and you know sometimes it takes a little while to get things done. In terms of the bilateral negotiation between the government of Israel and the U.S. Trade Representative on behalf of the U.S. government, it is a bilateral government negotiation. I intentionally did not want to address specific U.S. positions or even really the particulars of the Israeli position because that's really not my purview. It's not my remit. However, I would say that from the role that I have as an industry advisor, and actually Jacques is the vice chair of the industry advisory, where we also like your committee to give some small advice, and sometimes usually the government ignores it, and sometimes they take part of it. If you look at the CAFTA, which I was pleased that you cited, if you look at the free trade agreements, where Ambassador Zelek has made it almost a personal mission, a real deal, to get data exclusivity that's meaningful, that includes indirect or direct reliance, that starts from the date of marking in the second country, not in a reference country, for a period of interval of 5 years and 3 years for new uses. If you want to see what we believe, what we understand USTR is looking for, you can look at the CAFTA. And I was pleased that you cited that as something that would be nice for Israel as well.
Thank you very much, Susan.
To Ms. Weisman, I would like to say 2 things. One, when I was a little boy, I jumped maybe 20 centimeters. When I was older, with 4 years, I jumped 60 centimeters. I jumped 300% more. When I became older, and I jumped 1 meter 20, and then I increased it to 1 meter 25. This is about it. Now, I can only tell you one thing more, that in Israel, for Israel, we are promised when the extension of patent came into force, etc., that a lot of investment will come into Israel. I must tell you, it's promises, 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 and one thing I can tell you, whatever the patent system will be in Israel, whatever exclusivity data will be in Israel, investment in Israel will be done according if it is worthwhile for the international companies or it is not worthwhile. It has nothing to do with the intellectual property that exists. Now, Mr. President, you ignored with what I opened. I opened saying that I believe that the people who are investing, who are inventing, have to be fairly compensated. I opened my saying representations. But on the other hand, no abuse. If we can come to terms that there will not be abuse of the intellectual property by the multinationals, no problem to grant them a fair compensation. But as long as the abuse continues, as long as 4 years that we are opposing the patent, 4 years, 5 amendments are made on this patent. And up to now, no statement of case from the appellant, from the proprietor. This is not an abuse.
Thank you, Mr. Tomer. I don't wish to conclude. I think we can go on the whole day long. This has been totally fascinating. I wish to thank the audience for your participation and patience. Thank the panelists for their fascinating contribution and their cooperation. Somehow to be or not to be became to have or not to have. That's perhaps the way of the world. Thank you very much.